Hello, ladies and gentlemen. I'm Judge Deborah Nicastro of the Garfield Heights Municipal Court, and I want to give you an update on remote technology and Ohio courts. During the pandemic, the Chief Justice, Maureen O'Connor, issued administrative orders that enabled all the courts in Ohio to have remote hearings and remote proceedings of every type. Each court received at least $25,000 in grant money to set up Zoom and other platforms for these remote proceedings. Many lawyers, litigants, victim advocates have told me that they prefer to continue with remote technology even after the pandemic. As a result, last year the Chief Justice created the I-Court Task Force to establish rules and regulations for remote proceedings. I was honored to be appointed to that task force on behalf of municipal courts in Ohio. Our first challenge was to review all the statutes and all the rules of court that addressed in-person or other types of hearings. The Supreme Court staff prepared a comprehensive report which you can find online at the Supreme Court website. They prepared amendments to all the statutes and rules of court and submitted them to the Ohio State Legislature in January. The procedure for adoption of new rules in Ohio is that the Supreme Court adopts the rules, amendments, submits them to the legislature in January. As long as the legislature takes no action to disapprove those rules, they go into effect automatically on July 1st. All of us on the task force and many judges in Ohio assumed those new rules would be adopted that would promote the continued use of remote proceedings. Unfortunately, last week on Thursday, the Ohio legislature voted to disapprove the rules governing remote proceedings and all the updates that were recommended. We cannot resubmit those amendments until January of 2023. As a result, now for approximately the next 6 months, we will have to continue to operate under an administrative order of the Chief Justice if she decides to continue that order. Her term ends at the end of this year, so we don't even know if those orders will continue through this year or next year when a new Chief Justice takes office. As a result, I have decided in my courtroom that we will revert to the rules as they stand today. This has the most impact in criminal and traffic cases. Criminal Rule 43 requires that the defendant be physically present in the courthouse for proceedings. That presence can be waived by the defendant, but it must be waived in writing. And also, I would need a written plea, change of plea form be submitted with the waiver of a physical appearance. This is a challenge. We have explored many things such as DocuSign for remote signing. I do not feel that many of our constituents will be able to use that service effectively. If you as an attorney feel that you can accomplish that, I welcome your participation. But I'm going to assume that unless an attorney tells me, a defense attorney that is, tells me that their client will submit a written waiver and a written change of plea form before a change of plea hearing, that it will have to be in person. Of course, that takes us back to all the pre-pandemic problems our court in Garfield Heights has experienced. We're a very small building. We have limited parking. It's a challenge always to have parking. In the past, we've staggered our hearing dates so that both courtrooms aren't operating at once because of the limited space and parking. That space is even more limited when we try to have social distancing and other COVID-related health protections in place. So this is what we plan to do. We are going to reschedule the times for some prosecutors, and that discussion is going on now between my bailiff, Alex Gergat, and the prosecutors to come up with those times. Right now, civil proceedings will continue as scheduled remotely. where they are scheduled remotely. We will revisit those probably in August or September to see if we're meeting all the requirements of the civil rules. But starting in July, all proceedings for change of plea, trials or other evidentiary hearings will be in person, unless defense counsel files with the court at least 1 day prior to a change of plea hearing, motion hearing, or trial, the documents that I've just specified: a waiver of the physical appearance of the defendant in the court, and a change of plea form. If those are not filed, we expect defense counsel and the defendant to be physically in the courthouse at that time. And that will be how we'll proceed until we have further directions from the Chief Justice. All judges received an email from the Chief Justice last Friday indicating that the Supreme Court staff is analyzing the situation and will give us further guidance in the future. If you have questions, you can always call my bailiff, Alex Gergat, and he will bring you up to date on what needs to be done. Also, all our new scheduling orders will have these details ready when they go out, so you'll be able to read them again. Thank you for your patience. Let me just say, if you wish to continue remote proceedings in the future, I would suggest that you contact your state representative and have a serious discussion about how you think remote hearings benefit you and your client, give greater access to participants, witnesses, victims, defendants themselves, and encourage them to adopt the amended rules as suggested by the I-Court Task Force. Thank you. I look forward to working with you more in the future.